Good evening. This is John Milburn for Laws 12059 Conveyancing. We're into week 10. This week we're dealing with week 9 material, which relates to special conditions. This is the second last substantive topic that we'll cover in this unit. Next week we'll deal with remedies, leaving us into week 12, where you have your take-home examination. So the content tonight is based around your reading in chapter 8 in your text. So special conditions. There's some key terms. We'll talk about those tonight as we proceed through the discussion. If you have any questions, as always, please feel free to unmute your microphone and to ask any questions as we proceed. So condition precedence and condition subsequent. What are the difference? Well, for the most part, when we talk about a special condition or a condition, we're talking about a condition subsequent. But a condition precedent, in short, is where we can say that if something happens, then we have a contract. A condition subsequent is we already have a contract subject to something happening or something not happening. So you see the difference. Condition precedent really relates to the very formation of the contract and only occurs on the happening of a certain event. So most of the time when we talk about a special condition, we're talking about a condition subsequent. A grey area is, if you like, subject to formal contract, and it may be a condition precedent, it may be a condition subsequent, or it may be a condition that really has no effect at law. So it's more an administrative type condition. The leading case, of course, is Masters and Cameron, 1954-91 CLR 353. So depending on the circumstances, when you see a condition that is subject to contract in an agreement that's already signed, it may be binding on the parties, that is, the agreement may be binding on the parties if this formal contract never eventuates. In other words, it may be that the condition is a condition subsequent, a condition precedent, or it has no real effect at all. So for the most part, we're talking about condition subsequents. Now, a leading case that you would have read about in your material is Meehan against Jones, 1982 149 CLR 571. It's a good case by way of an example. In short, what happened is this. There was an agreement to sell some land, subject to the buyer obtaining enough finance. Fairly standard. Whether the finance was sufficient was left to be determined by the buyer. The vendor claimed the contract was void for uncertainty. Obviously, the vendor at that stage wanted to get out of the contract. So was that clause, subject to sufficient finance, void for uncertainty or not? The High Court said no. It is an obligation that's enforceable. However, there are a few conditions to this. The first is that the buyer must act honestly and reasonably when deciding whether the finance is satisfactory, and the court has a role to assess when the buyer is acting reasonably or honestly in those circumstances. So the court still has this supervisory role, and even though it says subjectively that it's subject to the buyer being satisfied, the court is there to determine objectively whether the buyer has acted reasonably in that regard. But the point is that it's possible to have a contract that is effective, notwithstanding that vague, what you might think is a vague clause. Now, in addition to specific terms as conditions subsequent or special conditions, be aware of implied terms. And courts will, and we see this in, say, Meehan and Jones, the court implying into that special condition the obligation to act honestly and reasonably. Have a look at Zyme against Gregory. It's 1963, Victorian Reports 214. So it's a little older, but in that case, the court said, where a buyer must make reasonable inquiries and apply for finance, then they may not unreasonably refuse any loan that is provided to them. In other words, it's not an option, and many people see it as an option, but a subject to finance clause is definitely not an option. There's still a positive obligation on the buyer, and this is Meehan and Jones, to act honestly and reasonably in pursuing the application. And then secondly, once the finance is presented to the buyer, having made the application, it's not an option as to whether they take it or not or proceed. They cannot unreasonably refuse or take advantage of any loan that is provided. So that's Zyme and Gregory. So do you see the two steps there and how this is really something that involves the seller and, if necessary, the courts as well? If there's a dispute about this, the question then is, who has the onus of proof? If the seller goes to court and says either the buyer is not acting honestly and reasonably in pursuing an application for a loan, or the buyer is acting unreasonably in refusing a loan that's offered to the buyer, is it up to the seller to prove the case in the usual manner? Or is there some sort of a reverse onus here where the court will say, all right, well, thank you for that information. Now, buyer, tell me what you did. You proved to me that you acted reasonably and honestly in pursuing the loan, or you acted reasonably in refusing the loan that was provided to you. What do you think? Where's the onus? With the seller or with the buyer? Any thoughts? You can use your chat facility for this if you like, and we'll look at the votes as they come in. Buyer, Sarah says the onus is with the buyer. Do we have any other votes? All right, buyer under equity, says Rachel. 2 for the buyer. I'll go with buyer. I agree with both of you. Thank you for that. The case, Zyme and Gregory, again, authority for that proposition, and probably Meehan and Jones also. Now, in the standard contract that we use for for real estate in Queensland, there is provision for the time for the fulfilment of the condition. But if no time is specified, either in the standard contract or generally speaking, the court will imply that the settlement is to be within a reasonable time, that is for settlement. And it's important to note that when we're talking about settlement, if you wish to set up a situation where time is no longer of the essence, or time is never of the essence, that you give a notice to complete to the other side, making a note that you reserve the right for failure for that buyer to settle, to terminate the contract. And if you don't do that, it may be that your termination is treated as a repudiation. So when it comes to settlement, you need to give a notice to complete. But as we'll see during our discussion tonight, that's really not necessary for the most part and almost always when we're dealing with special conditions. Let's have a quick chat about date of contract. We've talked about this previously. It's in the material. Typically what happens is that the seller will, or the agent for the seller, will will date the contract when the second party to the contract signs it. That's usually the seller. It doesn't have to be, but it usually is the seller, at least in Queensland. And whilst that's a standard practice to date the contract the day that the seller, being the second party, signs the contract, it's a little misleading in that, we'll go back a few steps here, is it truly a contract that's formed, or is there something missing? The buyer signs the contract, and I know I'm backtracking to maybe week 2 material here, but the communication, yep, that's it. So it's only once communicated. So if the buyer signs on a Wednesday evening, communication occurs on Thursday, then really the contract comes into existence on the Thursday, and it's misleading that the contract is dated on the Wednesday. And that also has an effect, of course, when we consider Section 166 of the Property Occupations Act in relation to cooling off periods for relevant contracts. The cooling off period under section 166 commences when the buyer receives a copy of the relevantly signed contract by both parties. All right, so let's come back to special conditions and think about the rights of termination for non-fulfillment. Again, this is in your textbook, so we're really following what's in the text tonight for the most part. If a special condition provides for the occurrence of an event and provides that the contract may be terminated for failure for that event to occur, I guess the question is, who has the right to terminate? Is it the buyer? Is it the seller? Is it either or both of them? Or is it no one? For example, I mentioned tonight the instance of Masters and Cameron, where you may have a contract that says, subject to formal contract, the formal contract doesn't occur, but you've still got an obligation on both parties potentially to settle, depending on the circumstances. So there are a range of different options here. Now, the general rule is this. If a contract is signed, is inserted for the benefit of one party, then only that party may exercise the right to terminate up to the date that the contract condition is to be fulfilled. So a good example is finance. If we provide in a contract that it's subject to finance by a certain date, the 20th of September, then the seller has no ability to terminate the contract until after the 20th of September. But the buyer may, even if the buyer doesn't obtain finance, waive the benefit of that condition and force the seller to proceed. In other words, even if the buyer doesn't get finance, it's there for the buyer's relevance or benefit, so the buyer can waive that benefit. And that particular example is specifically referred to in the contract, but it applies generally as well. So if a party has the benefit, then generally only that party may terminate for failure for that condition to be fulfilled. If, however, it's inserted for both parties, then either party can terminate without the consent of the other. In Perry against Cool and Gather Investments, 1982, 149 CLR 537, the High Court said that when the time has elapsed for performance of a contract, that is a condition in a contract, then either party, provided they're not in default, can elect to treat the contract as at an end if the contract has not been fulfilled or has not been waived. So if we have a condition for the benefit of a buyer, 20 September, come the 21st of September, then either party can terminate the contract based on the failure for that contract to be fulfilled. Let's have a look at the contract. If you've got your contract handy, please dig it out. I'd like you to look at firstly clause 3 regarding finance, and it simply states that where the contract is conditional upon the buyer obtaining finance, the buyer must take reasonable steps to obtain finance. So that's the Meehan and Jones principle. The seller may terminate if notice is not given to the buyer by 5 p.m. on the finance date. Clause 4 relates to building and pest, and it states that the contract is conditional upon the buyer obtaining a satisfactory inspector's report or waives that condition. Again, the buyer must take reasonable steps, and again, the seller may terminate if no notice is given by the buyer by 5 p.m. on the inspection date. Now contrast those provisions with clause 7.7, which relates to property adversely affected. In particular, town planning, transport, access to services, FIRB legislation. Now, by that clause, the buyer may terminate the contract in certain circumstances. If no notice is given, the buyer is deemed to accept the property subject to all matters referred to in that clause. Also refer to clause 10.4 of the contract, which provides for notices generally to be in writing, delivered or posted or sent by facsimile. But do note that in the contract, email transmissions they're not given that are not given until capable of being received by the person to whom they're addressed. And again, look at section 24 of the Electronic Transactions Act. Okay, so what we've discussed so far tonight is issues to do with waiving the benefit of conditions, considering for whom the benefit is conferred, considering what happens if the condition is not fulfilled or waived by the certain date, and we've now considered how you go about giving notice to the other side in that it must be in writing under the terms of the standard conditions or standard contract. Any questions so far, or all good? Okay, so let's talk a little bit more about a contract being inserted for the benefit of one party. As we know, if it's for the benefit of one party, even if it's not fulfilled, the buyer or that party, typically the buyer, is able to waive that benefit. The other party is not entitled to treat the contract as at an end, at least until the time for that condition has come and gone. Have a look at Sandra Investments against Booth, 1983, 153 CLR. And according to the High Court in that case, where a clause is inserted for the sole benefit of a party, it's for that party to determine whether or not to rely upon it. But still, that's subject to the Meehan and Jones principle that they must act honestly and reasonably. Contrast that to the situation where the contract condition is inserted for the benefit of both parties, then both parties have the right to terminate for non-fulfillment. And the situation is different if the date has come and gone, then the party for whom the benefit is not conferred may terminate the contract, and that's Perry against Coolangatta Investments. All good? All so far good, so good? All right. Now, a court will not allow a party to avail themselves of their own action or inaction to defeat the contract. In other words, the party must take reasonable steps. Authority, Perry and Coolangatta Investments, and of course Meehan and Jones. From a practical perspective, I think it's good conveyancing practice to specifically state whether a clause is inserted for the benefit of a party. That removes any argument and to some considerable degree uncertainty. Now let's look at a case, Associated Developers Pty Ltd, Associated Developers Australia Pty Ltd against Allied and General Pty Ltd. This was 1994 Queensland Conveyancing Reports 54-458, the CCH publication. So a contract was subject to rezoning and subdivisional approval. That was to occur by the 30th of June 1994. Settlement was 28 days after receipt of the approvals. Now on the 29th of June, the buyer waived the benefit. The seller refused to accept the waiver and purported to terminate the contract on the 1st of July. So you see the picture? Justice Thomas of the Supreme Court concluded the clause was for the benefit of the buyer, and therefore the buyer was entitled to waive it. So from that case, we conclude that a condition capable of unilateral waiver by the benefit of the party does not lose that quality because the completion date is fixed by reference to the occurrence of that condition. So again, you need to be careful in your drafting. That's a case that shows that is the situation. Let's look at another case, Willing against Baker. Willing against Baker. This is 1992 58 SASR, South Australian State Reports, at 357. The court held that a condition-making contract subject to the buyer entering into a contract to sell a property was found to be solely for the benefit of the buyer, who is entitled to waive that condition. Again, good drafting, and we overcome all of these issues. Now, let's look at the situation where the contract is inserted for the benefit of both parties. Then, of course, the situation is that either may unilaterally, without the consent of the other, terminate the contract in the event that the condition is not fulfilled. Now, a few more specific examples. Finance is a very important one. Again, the starting point when we're thinking about finance and clauses is to look at the contract. So always go to the contract. In this instance, go to clause 3. And it simply says that it's subject to the buyer obtaining approval for a loan on terms satisfactory to the buyer. The buyer must take reasonable steps, and failure to give notice allows the seller to terminate the contract if the date comes and goes. So that's all pretty straightforward, isn't it? And we have an idea of what's meant by the term on terms satisfactory to the buyer. We've talked about Meehan and Jones, but also look at an earlier case, which is Gagliardi and Lamont, 1976 QDR 53. Now, of course, when I studied conveyancing, property law, they said now we have a recent case, Gagliardi and Lamont, from 1976. Now, the buyer waived the benefit of a finance clause. The seller refused to accept the waiver, and the buyer sought an order for specific performance. Based on what we've discussed so far, you'd think that's a pretty easy case to resolve. We now know what the position is, but we didn't in 1976, so this was all new. And the court held, Justice Matthews held, that the buyer did have the right to make the application and decide the basis of it, but again, not to act unreasonably or capriciously. And we saw that reflected in Meehan and Jones. Where it gets trickier is where we have an approval of a loan of finance in principle. I guess we see that sometimes. In principle, your finance is approved. What does that mean? Now, if you're a buyer, of course, you have the right to simply waive the benefit and say, I'm waiving the benefit of the finance clause based on the in principle approval. But the buyer's taking a risk because in principle does not mean approved, in my view. So Bronwyn says, good practice, don't approve until formal approval is given. I think that's right. It might be that it's approved in principle, subject to the buyer obtaining a life insurance policy. The buyer attempts to obtain a life insurance policy and finds there's some medical condition precluding him or her from obtaining that. So Sarah says formal unconditional approval. So we do see in practice this distinction between in principle as opposed to unconditional approval. Now let's think about the steps. There's a requirement to take reasonable steps to obtain approval. And it says that in the contract. The implication is that the buyer needs to borrow that amount, which is inserted in the finance clause, to complete the transaction. So if the acquisition is for $500,000 and it says in the contract that it's subject to the buyer obtaining finance $400,000, one can assume from that that the buyer needs to borrow $400,000 in order to complete. What happens though if the buyer applies for finance which is rejected and you find out that the buyer applied for $425,000? Has the buyer acted reasonably in those circumstances? What do you think? Has the buyer taken all reasonable steps necessary to fulfill the obligations under the finance clause? Rachel says no. Any other votes? We're slow on the buzzers tonight. All right, I'm going to go with no. I agree with Rachel on that one. Thank you, Rachel. Okay, are we ready for a case? This is case number 14. You know that means time to concentrate hard. If you're watching this as a recorded session, please pause the recording, get your paper and pen out, make some notes. We'll see if we can identify some issues and perhaps some answers. You're engaged by buyers of a residential property. The agent completes the contract by inserting a finance amount of $400,000 and nominates the financiers as a financial institution. The finance date is 12 September 2018. On the 12th of September 2018, your client consults you. They bring a letter from XYZ Pty Ltd with approval of a loan of $400,000. The interest rate specified in the approval is 10% per annum. They thought they could obtain interest at the rate of 4% per annum, but it was 10%. Your clients want to terminate the contract. What advice do you provide? What steps do you take? Now, any thoughts? What advice do you give? What steps do you take? On the face of it, you've got a finance approval for the amount specified in the contract. Any thoughts?
It's got to be suitable.
So Rachel said, yep, Rachel?
It's got to be suitable for the buyers, and depending on whether they can afford the 10%, because that can be a very big issue if they can't afford it. So it's certainly got to be suitable.
All right. So I take it from that, Rachel, that you would say to your clients, yes, I'm happy to accept your instructions to terminate the contract, and I think you're on safe grounds to do so. Sarah says, correct me if I'm wrong, Rachel, Sarah says they acted reasonably, however, not satisfactory to the buyer, therefore they can terminate. So shares that view. Bronwyn says it doesn't have to be, it does have to be on satisfactory terms to the buyer. And Sarah says can terminate. Right. I agree with all of you. I think that the buyers are entitled to terminate. I think the standard provision says that it must be on terms satisfactory to them, and that is, I think, a fairly clear instance of where they're entitled to say that is not satisfactory. I mean, it's going to be difficult and very, very awkward if they had hoped to obtain finance at 3.5% and they get approval for a loan at 4%, then we're in some difficult circumstances. Now, what is the significance, though, of this point? So in the scenario I gave you, the agent prepared the contract saying that the financier is a financial institution. The clients bring to you a letter from XYZ Pty Ltd. Does that change your view? Are the buyers still entitled to terminate the contract? Sarah says, as long as they're acting reasonably, says Bronwyn. Sarah says no. So I think we have a yes and we have a no. Any other votes?
Is XYZ a financial institution?
Yes, it is. Good point. It is. All right. I think that they've got problems. Now, it may amount to nothing. Sarah says if they're not specified, if they are specified, then unfortunately they have to have approval from that bank. Turn it in to find out whether they have to provide two. Yep. So Bronwyn says you need two letters from financiers. I think that the sellers are entitled to say that because the clause was drafted a financial institution, there is a necessary implication that if the buyers are not satisfied with one, they might try another. But what do you do? Like, you've got 14 or 21 days. Do you make two applications? Are you dealing with two competing financiers at the same time? It's a very difficult area. But I think that if we refer to Meehan and Jones and Zyme against Gregory, the buyer who only attempted one financial institution may be in difficulty. So a safe option may be for the buyers to at least apply for an extension and be upfront to say that they're doing their best, but they need more time, and that puts it back on the seller then to approve or not approve the extension request. But the second scenario is a tough one. I mentioned about providing notice, and the notice needs to be in writing. What happens if the date which is mentioned in the contract happens to be a public holiday or a weekend? What happens then? Do you have to give notice on the Sunday? Reverts to the next business day. Okay. And that's in the contract, isn't it? Andrea says on the next business day. Thank you. So note clause 10.5 subsection 2 in that regard. The notice must be in writing. Take care with email communications. And remember, of course, the communication needs to be to the seller, not the seller's real estate agent. Let's look at a case, Hill against Terry. It's an older one, 1993 to QDR 640. In Hill and Terry, we had a house contract subject to finance. Contract provided that the buyer did not terminate for failure to obtain approval or waive the benefit, the seller may terminate. So pretty straightforward, pretty standard. There was no waiver, there was no approval, the seller did terminate. Now, the trial judge said the seller's conduct was unconscionable and granted the buyer specific performance of the contract because the buyer was able to obtain the approval, but just a little late. The Court of Appeal reversed that decision. And the reason I'm mentioning this is, as recently as 1993, this was kind of up in the air. But now we know through a series of cases, a common theme that when it comes to conveyancing, times being of the essence is treated as of the essence, and it's very difficult in general terms to mount an argument of unconscionability in these circumstances where the other side is simply acting in accordance with the contract and purporting to exercise a right. And the basis for this was through Justice Ryan and Justice Byrne, that the seller was under no fiduciary obligation to the buyer in relation to the power of terminating the contract, that they could look after their own interests and they're entitled to do that. So their conduct was not unconscionable. There was nothing that of itself created any form of estoppel. And in fact, if they had inactivity, might have then created a waiver situation or against them, or a condition in relation to failing to act reasonably within a reasonable time. So again, we see that Hill and Terry type philosophy now very much at the forefront of how these cases are decided. FIRB. Now, is FIRB referred to in the contract? It is, but I'm just getting to see if you know where it is. So where is FIRB referred to in the contract? I'm looking for a clause number. So who's first on the buzzer? And again, I'm looking at the 14th edition of the standard. Acquisition for residential real estate. 10.2, we'll give that one to Sarah, thank you. So 10.2 talks about foreign buyer approval, which is FIRB. It's a bit of a trick question because it doesn't actually say FIRB, but it's the acquisition approval through the Foreign Acquisitions and Takeovers Act 1975, which is Commonwealth legislation. going to share the screen because I want to refer you to information on the Australian Government Foreign Investment Review Board website, which provides some useful information and some quick guides that will hopefully assist you if you have one of these issues down the track. So with luck, you can now see the web page for firb.gov.au/resources/guidance. And if you look at the residential real estate overview document, it provides the basis upon which the government, the FIRB, will consider the process of applying and receiving approval. And the approval is generally for new dwellings, residential, and vacant residential for development. Those approvals are usually given without conditions. The idea, the philosophy behind this, of course, is for it to provide an impetus, jobs, employment. So that's why they like new dwellings or ones that are being built. Applications for the purchase of vacant land, usually approved provided construction is commenced within 4 years. You can't just sit on it for a long time. And once they're built, they need to be rented out, sold, or retained for their own use. And established dwellings, much more difficult because in those circumstances, it's not seen as generating income for the benefit generally of the economy. All right, pool compliance. Where in the contract does it refer to pool compliance? Sarah won last time. See if she can retain her on the quick on the buzzer title. Which clause? Pool compliance? (4.2). Rachel got it. Okay, thank you, Rachel. Thank you, Sarah. Bronwyn just got in behind that. So have a look at 4.2, which brings me to case number 15. So we're ready to concentrate. Pens on the ready. Make some notes as we speak. And I've called this one case number 15, giving notice of termination. We have a standard form contract. The buyer failed to notify satisfactory building and pest inspection before 5 p.m. Soon after 5 p.m, the seller purported to terminate the contract. After receiving the termination notice, the buyer sent a satisfactory notice of inspection. Really quick succession, but after 5 o'clock. You're acting for the buyer. What can you do? What should you do? So do you see that it's a very stressful situation? So firstly, what are the issues? Well, you consider the first place you'd look is clause 4 of the contract, 4.2. You'd consider the rest of the contract. Is there anywhere else in the contract that you think? So Sarah says, firstly, they have a continuing right. Who's that? The buyer or the seller, Sarah? The buyer?
Buyer, sorry.
The buyer. Now, the question is, though, does the buyer have a continuing right if the seller has purported to terminate the contract after 5 o'clock? The buyers may well have an ongoing right, but have they lost it? Is the contract gone? Is it gone that moment at 5:02 when the seller said, I'm sorry, you had till 5 o'clock, we're terminating the contract? So Sarah says, yes, they have lost it. Rachel says, it's back to that issue of time of the essence. How serious are we when we talk about time of the essence being 5 p.m. on a certain day? Are there any other clauses in the contract that might be relevant to this discussion if you are standing in front of a judge arguing for your buyer? If you're watching this as a recorded session, you should be scouring the contract now. Anything that comes to mind? Rachel says, was there a natural disaster? Good point. Let's assume there wasn't, but it's a good point. What about clause 10.4? Is there anything in there that might change the situation? What about 10.4 subsection 5? Does that change things? So 10.5 says, 10.4 subsection 5 says, notices given after 5 p.m. will be treated as given on the next business day. So does that mean the seller's notice was deemed to be given the next business day? If so, could you argue that the buyer's notice, although it was later in time, takes priority? Or if not, could you argue that both notices were deemed to come into effect essentially in a nanosecond after midnight, in other words, simultaneously? If you're a buyer, do you lodge a caveat? Do you apply for specific performance? If you do, which court? Or do you do both things? So they're the sorts of things that you'd need to discuss if this was part of, for example, a take-home exam question. So this scenario is based on a real case, Simpson against Jackson, 2014 QSC 191, Simpson and Jackson. It's a decision of His Honour Justice Applegarth. Justice Applegarth writes really good decisions. So if you see one of His Honour's decisions, you can pay particular note of it. The paragraphs that you might want to consider in reading the case are 20, 21, 23, 24, 25. Sorry, I haven't given you the authorised citation. Now, I'll just go through it briefly. And 20 says, at a broad level, the intention of the parties was that the property should be sold and the sale go through to completion. However, that is to state the intention of the party generally. But insofar as the parties intended the contract be performed, it was subject to the more specific rights, which give both parties the right to terminate in certain circumstances. So, it can be said the parties' intention were that if the buyer did not give written notice to the seller of satisfaction under clause 4.2 by 5 p.m, on the inspection day, the seller should have a right to terminate. And in that context, it can be said that the principle of contractual certainty should enable a party who has that right to exercise the right without fear that that right will be subverted, rendered nugatory, or turned back upon them somehow. 21. It seems to me that even if we were to accept the buyer's argument that the notices should be deemed to be given simultaneously, notwithstanding the absence of words to that effect, it would result in a conclusion that written notice was given by the buyer before termination. It would lead to a perplexing conclusion that both notices were given precisely at the same time, leaving everyone to guess which one, if either, is to be effective, and that's not a construction that we prefer. At 23, His Honour said, in my opinion, the sensible interpretation of the provisions is that clause 10.4 subsection 5 treats the notices as having been given on the next business day. That has implications as to reckoning of time, but they should not therefore be treated as having been given in a different sequence or simultaneously. For other reasons that were exposed in the course of arguments, I consider that the notice of termination was therefore effective it did effectively terminate the contract. The contract having been terminated by the sellers, the buyers do not have an entitlement to specific performance. The seller is entitled to relief sought under the counterclaim declaration. The contract had been validly terminated. The caveat be removed from the title, and of course from that any other consequences might flow. So that case is important because very clearly His Honour set out the legal position, said let's not argue over this nonsense. If someone gives the notice and they're entitled to give the notice, let it be, and you can't use 10.5, 10.4 in a creative manner to subvert that notice that was given lawfully. So that's Simpson against Jackson. It's also a useful case because it gives you a very clear idea as to the court that you should consider in an application of this type, and the type of order that you would seek, either for the buyer or the seller. So it's useful in that broader sense as well. All right, thank you. That's it for this evening. Unless you have any questions or comments, I'm sorry I can't give you any advice in relation to the second assessment. It's due tomorrow, but some people have submitted their work, and good on you for doing so, but you'll understand that I can't therefore comment about that in specific terms. All good? All right, no questions? Thank you for your patience and attendance this evening. We'll see you next week. And if I could just ask a favour, make sure you submit your work on time, and I'll try to get that turned around and back to you as quickly as I can. All right, all the best. We'll see you next time.